So, welcome class. Today we are discussing uh, the chapter 4 of the Indian Penal Code from 76 to 106. Very important chapter for the purpose of your mains examination as well as for the purpose of your preliminary examination. Reading the BR Act is very much important. So, if anyone having any issue to read it from the screen, I'm sorry, please have a BR Act with yourself so that you can follow. Today, my health is not good so much, though we will continue in a slow tempo. Okay. Now, section 76 to 106 of the general exceptions. Section 76, the general exception means what are exceptions? General exceptions are those exceptions which can absolve a person from a criminal liability. So, if anyone is charged with a crime and that person, or that we can say that he has committed no offense. So, starting from 76, this reading is for the purpose of maintaining the bare act in a clear-cut manner within your mind. Okay, so please follow. 76, act done by a person bound or by mistake of fact, believing himself bound by law to do it. Okay, so 76, done by a person bound by law or by mistake of fact, believing himself bound by law. So nothing is an offense. See, first is the criminal liability is absolved. Nothing is an offense which is done by a person who is or who by reason of mistake of fact and not by reason of a mistake of law. So that mistake must be a mistake of fact and not by reason of a mistake of law, in good faith believes himself to be bound by law to. So if anyone does an act under the impression that he is bound by law to do it, or by reason of what? Of a mistake of fact and not by reason of a mistake of law, in good faith. This is very important. In good faith. Whatever have been done, that must be done in good faith, believing himself to be bound by law to do it. Okay. Now illustration, a soldier fires the order of his superior officer in conformity with the commands of the law. A has committed no offense. Now illustration B, A, an officer of a court of justice, being ordered by that court of to arrest Y, and after due inquiry, remember this, after due inquiry, believing Z to Y, arrest Z. A has committed no offense. Okay. Now section 77, act of judge when acting judicially. So nothing is an offense which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law. So anything done by a judge under the power which has been granted to him or which in good faith he believes to be given to him is not an offense. Okay, that has been mentioned in section 77 of the Indian Penal Code. Now 78, act done pursuant to the judgment or order of court. So act done pursuant to the judgment or order. First one is bound by law. Okay, first one is bound by law or uh, mistake of fact, believing himself to be bound by law. Second one is 77, act of a judge acting judicially. Third, 78, act done pursuant to the judgment or order of a court. Nothing is done, nothing which is done in pursuance of or which is warranted by the judgment or order of a court of justice, if done while such judgment or order remains in force, is an offense. Notwithstanding, the court may have had no jurisdiction to pass such judgment or order, provided the person doing the act in good faith believes that the court had such jurisdiction. Now you can see that in the as far as section 76, 77 and 78 is concerned, the word good faith is very important. So nothing which is done in pursuance of or which is warranted by a judgment or order of a court of justice, if done whilst a judgment or order remains in force, is an offense. That means nothing is an offense. And notwithstanding, the court may have had no jurisdiction to, even if the order is without jurisdiction. In that case, also, if for the compliance of the order of the, or for the execution of that order, if somebody has done something, believing that order to be a valid order, then in such cases also, that person has committed no offense. Okay. So The second part says, notwithstanding the court may have had no jurisdiction to pass such judgment or order, provided the person doing the act in good faith believes that the court had such jurisdiction. Okay, so good faith is important. Now 79. This is, we have read, that is bound by law or by mistake of fact believing himself to be bound by law. Now in this case 79, act done by a person justified or by mistake of fact believing himself to be justified by law. This is very confusing sections, so always remember 76 is bound by law and 79 relates to justified by law. Now nothing is an offense which is done by any person who is justified by law or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be justified by law in doing it. So nothing is an offense which is done by any person who is justified by law or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be justified by law in doing it. So if somebody or any person who is in general justified by law, or if in that particular cases he is not justified by law but due to a mistake of fact and not by reason of a mistake of law in good faith believes himself to be justified by law in doing it, then such person has committed no offense. Let's see the illustration. A sees Z commit what appears to A to be a murder. It appears to A to be a murder, but in actual circumstances or scenario, it may not be a murder. Okay. A, in the exercise to the best of his judgment, exerted in good faith of the power which the law gives to all persons apprehending murders in the fact, seizes Z. So, A, as a law-abiding citizen and under the circumstances, what he did? He apprehends Z in order to bring Z before the proper authorities. So A thought that Z has committed murder and he apprehends Z, and what is the purpose? The purpose is to bring him to the proper authorities, and everything is done by A in this specific illustration is done with a good faith. Okay, in good faith. A has committed no offense, though it may turn out that Z was acting in self-defense. Okay. It may turn out that Z was acting in self-defense. That is, the scenario is not of a murder, but the scenario is of a self-defense. For the purpose of protecting Z's own body or property, Z has committed or killed another person, which appears to A that Z has committed murder. But if Z, I mean in this case, if A apprehends Z, so apprehending a person without any reasonable cause is an offense. Arresting a person or restricting a person of his free will and movement is an offense. But because of the fact that Z what did it with good faith and by mistake of fact, okay, and he thought he is justified in so doing. So this is 79. Now coming to 80, remember accident in doing a lawful act. Now accidents the part and parcel of life. So nothing is an offense which is done by accident or misfortune and without any criminal intention. Remember this very clauses. This is very important for the purpose of preliminary examination. That nothing is an offense which is done first of all by accident or misfortune and without any intention or criminal intention or knowledge in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. So just any other act, you cannot seek absolvence from the criminal liability for any other act or just any act. You have to prove it that that thing has happened due to accident or misfortune and without any criminal intention or knowledge. That is, knowledge means that that thing may likely happen. That may likely happen, that thing may likely happen, this knowledge is absent. Without that knowledge in doing of a lawful act, or if you are performing a criminal act or unlawful act, then this section 80 will not be of any help to you. But if you are doing a lawful act in a lawful manner, lawful act is not enough. That lawful act, doing of that lawful act must be in a lawful manner and by lawful means and with proper care and caution. Okay, if these things are satisfied, then one can be absolved from his criminal liability, because section 80 says nothing is an offense which is so and so. Okay. Hatchet. Hatchet, you know, the wood chaffers. A is at work with a hatchet. The head flies off and kills a man who is standing by. Here, if there was no want of proper caution on the part of A, his act is excusable and not an offense. Okay. Now, in case of accident, his act is excusable. He can be excused from the liability, from the criminal liability, because there was no want of proper care or caution on the part of A. If there was a that is the situation that A knew that it may happen, and if he had to take some precautionary measures for the purpose of any, for the purpose that any accident doesn't happen, the bystander, or the person standing by may have warned him, warning him. It is a duty of A, in such a case, if A presumes the condition of the hatchet is such that the blade of the hatchet may fly off. Now in such a case, it is the duty of the A to warn the bystander to leave off the place, or stay aside of his, the from the what to say, from the curves of the flying hatchet. Okay, from the curves of the flying hatchet. Okay. Now section 81, act likely to cause harm but done without criminal intent and to prevent other harm. Now this is very interesting. What has been said here is that act likely to cause harm, there, because the person doing the act knows that it is likely to cause harm. See, in case of 80, there is without any criminal intention or knowledge of doing the act. Okay. Now in section 81, it is what? Act likely to cause harm but done without criminal intention and to prevent the other harm. That means here in 81 there is knowledge but there is no criminal intention. And what is the purpose? Then if there is knowledge that act likely to cause harm and without a criminal intention, then what will be the purpose of that act? That purpose is to prevent other harm. This is 81. Okay. What has been said here is that nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm, if it be done without any criminal intention to cause harm, and in good faith for the purpose of preventing or avoiding other harm to person or property. So, nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm. Merely, the word merely is very important. Just because you have knowledge that it may likely to cause harm, it will not be an offense. Under the circumstances, what? If it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property. Now explanation. It is a question of fact in such a case whether the harm to be prevented or avoided was of such a nature and so imminent as to justify or excuse the risk of doing the act with the knowledge that is likely to cause harm. So whenever you are I'm extremely sorry, whenever you are seeking the help of 81, or the trying to get the help of general exception under section 81, you have to, it is a question of fact in such a case whether the harm to be prevented or avoided was of such a nature and so imminent as to justify the or excuse the risk of doing the act with the knowledge that it is likely to cause harm. Okay. You cannot jeopardize 100 people's life for the purpose of saving only one child. Okay. Now that cannot be justified. In such a case, section 81 will not be of any help to you. But if you see that one life, if you have one life on your boat, suppose you are driving a boat and you have one person as a passenger, and the other boat is carrying 100 passengers. Now in such a case, You cannot jeopardize the other boat or the lives, 100 lives of the other boat for the purpose of the one passenger with you. Okay, now if we see the illustration, it will be very clear. See the illustration. Say very important illustration, slowly read with me, it will be a crystal clear point. A a the captain of a steam vessel suddenly and without any fault or negligence on his part finds himself in such a position that before he can stop his vessel, he must inevitably run down a boat B. So the captain of the steam vessel, that is A, finds himself in such a situation. What? So before he can stop his vessel, he must inevitably run down boat B with 20 or 30 passengers on board unless he changes the course of his vessel. And that by changing his course, he must incur risk of running down his own boat, he must incur of running down a boat C with only two passengers. You see, suppose you are driving a ship and on your left corner there is a boat of 20 or 30 passengers, and on your right corner there is a boat with two passengers, and the circumstances are such you have to turn it down in either way. Okay, now what will you do here? If A alters his course without any intention to run down the boat C and in good faith for the purpose of avoiding the danger to the passenger in boat B, he is not guilty of any offense or an offense, though he may run down the boat C by doing an act which he knew was likely to cause that effect, if it be found as a matter of fact that the danger which he intends to avoid was such as to excuse him from incurring the risk of running down boat C. Clear? Now illustration B. This is a small illustration. Just read with me. Okay. What? A in a great fire pulls down houses in order to prevent the conflagration from spreading. So A in a great fire pulls down houses in order to prevent the conflagration from spreading. He does this with the intention in good faith of saving human life and property. Here, if it be found that the harm to be prevented was of such a nature and so eminent as to excuse A's act, A is not guilty of any offense. Okay. Now 82, very important. This is the provision of what? Act of a child under 7 years of age. Nothing is an offense which is done by a child under 7 years of age. This is the doctrine of doli in pax, because that child is not capable of committing any offense. Why? Because he has not developed that kind of cognitive mental faculties to form an intention to commit a crime. Okay, that's why nothing is an offense which is done by a child under 7 years of age. This is section 82. 83, act of a child above 7 years under 12 years of age of immature understanding. Now, first 82 says of under 7 years is nothing is an offense. Now, if the child is above 7 years and under 12 years, what will be the case? Now, nothing is an offense which is done by a child above 7 years of age and under 12 years of age who has not attained sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. Okay. So, in case of child under 7 years of age, under section 82, it is a blank carpet. But in case of from 7 to under 12 years of age, there is some fetters. What are they? Nothing is an offense which is done by a child above 7 years of age, under 12 years. What? Who has not attained sufficient maturity. Now, in the case of section 83, court will see that whether that child has attained sufficient maturity to understanding understanding and judging the nature and consequences of his conduct or not. If the court finds that the child has not attained such a sufficient maturity, it is not an offense. But if the court finds that from the circumstances and previous and subsequent conduct of the child that he has attained such a maturity to form an intention to commit a crime, then that will be an offense. Okay. Now 84, act of a person of unsound mind. So 82 is children under 7 years, 83 is children but above 7 years, under 12 years, and 84, act of a person of unsound mind. Nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act, and that he is doing what is either wrong or contrary to law. So, if the person is of unsound mind and it is proved that he is incapable, he is unsound to what extent? To such an extent that he is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. In such a case, anything done by that person is not an offense. 84. Now coming to 85. Act of a person incapable of judgment by reason of intoxication caused against his will. See, intoxication is not enough. Voluntary intoxication will not help you in any case. For the purpose of putting your case under the provision of the general exception under section 85, that intoxication must be against your will. Okay. So section 85 says nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication incapable of knowing the nature of the act. In case of 84, we have just read that that person is of unsound mind and that unsoundness of the mind is natural. Okay. And 85 is also kind of an unsound mind, but this this unsoundness of mind is due to the cause of intoxication. So nothing is an offense which is done by a person who at the time of doing it is by reason of intoxication incapable of knowing its nature, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him was administered to him without his knowledge and against his will. This is important. So, if anyone is intoxicated, knowledge and against his will, because if there is no knowledge, how can you expect the willingness of that person to be indulge in intoxicating substances? Okay. So first of all, there is no knowledge. Either there is no knowledge, and if there is knowledge, then he must, after getting knowledge that the substance or the drink is intoxicating in nature, he must have refused, and that person have been, by whether by force or by any other means, uh, against his will he have been intoxicated. So in such a case, if after the intoxication, I mean the effects of the intoxication strokes his brain and he loses his sense of judgment, then anything done by that person is not an offense. Okay. And what will be the criterion or the criteria to avail these sections help? First of all, the intoxication must be against his will, and the effect of the intoxication is to an extent in which that person becomes incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. You see, the same language has been provided in 84 in case of unsound mind. There is also in from the second line, is incapable of knowing the nature of the act or what is either wrong or contrary to law. So 84 unsound mind, 85 intoxication against his will is not an offense. Okay, I mean, in person intoxicated against his will, and that person if commits something, that will not be an offense. So now these are the very important case laws provided here that says voluntary drunkenness is no excuse for commission of a crime. You may, if you want, you may note down these case laws to your notebook. So, in which case it has been held in Mirza Ghani Bagh versus State of Andhra Pradesh, 1997. It has been held that voluntary drunkenness is no excuse for commission of a crime. If that has been permissible, then you can imagine what will be the scenario. Anyone who have rage against another, just drinking a bottle of intoxicating substance and killing that person will be permissible. Okay, so that's unimaginable thing. But these questions also arose before the honorable courts. Okay, and now situations arose, and the courts, honorable courts, have to declare these rulings that voluntary drunkenness is no excuse for commission of a crime. Now to Mirza Ganibag versus State of Andhra Pradesh. Now, in case of intoxicating, or in case of, I mean, 85, intoxication caused against the will of the person accused of an offense, this case is very important. What? Mirza Ghani Bai versus State of Andhra Pradesh. Another principle laid down is, so far as knowledge is concerned, the standard of test is same as in case of intention. Okay, so if the how knowledge. Okay, now, so far, now going to the section incapable of knowing the nature of the act. This is referring to the word knowledge. Okay, so far the knowledge is concerned, standard of test is same as in case of intention. And another principle laid down that the court must attribute to the intoxicated man the same knowledge as if he was quite sober, unless he was besides his mind altogether at the time of the incident. Okay, so these are the principles. Always remember the case law. Mirza Ganibai versus State of Andhra Pradesh is a very important case law in case of section what, 85 of the Indian Penal Code. Okay, now coming to 86. Offenses requiring a particular intent or knowledge committed by one who is intoxicated. Now, intoxicating person, we have just read 85, starting from 85. Now, here the intoxicated person committing an offense which requires a particular intent or knowledge. So what will be the case, whether that person have that intention or knowledge or not? How will it be decided? Now section 86 comes to rescue in such a situation and says, in case where an act is done or act done is not an offense unless done with a particular knowledge or intent, a person who does the act in a state of intoxication shall be liable to be dealt with as if he had the same knowledge as he would have had if he had not been intoxicated, unless the thing which intoxicated him was administered to him without his knowledge and against his will. So, in such a case, the presumption will be that the person, accused person, have the required knowledge and intention, unless he proves that the thing administered, or the thing administered intoxicating in nature was administered to him without his knowledge and against his will. In, if that thing is proved, then only section 86 can rescue that person. Otherwise, he will not be absolved from criminal liability. Okay. Now comments. Again, that case, this is intoxications related case, that is Mirza Ganibai versus State of Andhra Pradesh. The prosecution has to prove that in spite of drunkenness, the accused had intention to commit the act forbidden by the law. This is the duty of the prosecution, to prove that the accused person has the required intention. And another principle, sometimes intention on the part of the person who is drunk can also be asserted or assessed from the nature of weapon used in the commission of the offense. If a person uses a weapon which is not dangerous and the attack results in death, a malicious intention cannot be drawn against him, even though drunkenness is no excuse. Okay. Now, suppose if that person uses just a lathi and have give a few strokes to the person who has been killed, or for the purpose of murdering whom the proceeding is going on, and if it has been found that in general circumstances, from the post-mortem report, it has been found that in general, that kind of strokes by a lathi doesn't kill a person at all. Okay, but in the specific case, something has happened, or some, some, what to say, very sensitive part of a body have been hit by the person, and due to which accidentally this cause of death, the occasion of death has been arised. Now in such a case, that person cannot be charged with the required criminal intention to commit that offense. But if that person, instead of a lathi, uses a sharp edged, to say knife, which is at knife, and what, not only using the knife, he uses that knife and stabbed at the heart of the person, at the chest of the person, and cut the throat of the person. These, in such cases, it cannot be said that that person had no intention to commit such kind of, or killing that person. Okay, it is quite evident. The principle of res ipsa loquitur kind of thing, that is, thing speaks for itself. When you are trying to cut the throat of a person, your intention is simple, that you want to kill that person. Okay, so Mirza Ganibai versus State of Andhra Pradesh is important. Now 87. Act not intended and not known to be likely to cause death or grievous hurt, done by consent. So first of all, from it is consent. Now what is act not intended and not known to be likely to cause death or grievous hurt? Okay, nothing which is not intended to cause death. First of all, there is no intention to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt, is an offense by reason of any harm which it may cause or be intended by the doer to cause to any person, first of all above 18 years of age, who has given consent, and whether express or imply, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause any such person who has consented to take the risk of that harm. Okay, now if we go to the illustration of section 87, it will be very clear. Illustration says A and Z agrees to fence with each other for amusement. Now this agreement implies the consent of each to suffer any harm which in the course of such fencing may be caused without foul play, and if A, while playing, remember this, fairly hurts Z, A commits no offense. But if A uses foul means, and in using or playing by foul means he hurts Z, he has committed offense. Okay, it's as simple as that. Now the general rule of the game, while you are entering into a game of fencing or fighting, now in such a case it is presumed that you have consented to the inevitable injuries. But inevitable injuries to what extent? Not to cause death of yourself by the other side. You have consented to inevitable injuries which may result or which may be caused to your body during the game, by when the other party is playing by fair means, not by foul means. Okay, so this is the case of section 87. Now coming to 88, act not intended to be cause death, done by consent in good faith for person's benefit. Okay, this is another important, a very important. 88 relates to the profession of the medical surgeons. The illustration will tell about it. Now if we go to the section, body of the section says, nothing which is not intended to cause death is an offense by reason of any harm which it may cause or be intended by the doer to cause. So nothing which is not intended to cause death, first of all, is an offense by reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to any person for whose benefit it is done. Remember, in 88, it is for the person whose benefit it is done and done in good faith and who has given consent, whether express or implied, to suffer that harm or to take the risk of that harm. Okay, now this is case of another case of consent. Now illustration says a surgeon, knowing that a particular operation is likely to cause the death of Z, who suffers under a painful complaint, but not intending to cause Z's death and intending in good faith Z's benefit for Z's benefit, performs that operation on Z with Z's consent. A has committed. If in such a case the death of this patient Z happens, then A has committed no offense. That's why before conducting or performing a critical operation or life-threatening operation, there is a provision of signing a bond paper. You may have seen it in very television serials and movies. Okay. Now coming to 89. Section 89 says, act done in good faith for the benefit of child or innocent person by or by consent of guardian. Now, from if we come from what 87, it is said, first of all, done by consent, act not intended and not done by consent in good faith for the person's benefit. First one is by consent and this one is done for the person's benefit. Okay. Now, within the section from the last, the second line, who has given consent, within the body of the section, it has been mentioned that the person has given consent. Okay. That's why the signing of the bond procedure is there. That means that person giving consent that if, God forbid, if anything happens, the doctor will or the surgeon will not be liable for anything. Okay. Otherwise, any surgeon or no one can will take the risk of operating a dying patient to relieve him from his pain, because um, nothing is in the hand of the, life and death is not in the hand of the doctors. Okay. So 88, and now coming to 89, it is said that act done in good faith for the benefit of child or insane person by or by consent of guardian. Because for, if it in case of a child and insane person, it is the guardian who give the consent, because the very person or children has not have the capacity to give consent for such an act. So body of the section says, nothing which is done in good faith for the benefit of a person under 12 years of age. So what is the criteria of a child or being to be called as a child or taking the benefit as a child under section 89 is under 12 years of age. So nothing is done in good faith for the purpose, nothing which is done in good faith for the benefit of a person under 12 years of age and of unsound mind by or by consent, either express or implied, if the guardian or the other person having lawful charge of that person is an offense. Okay. By reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to that person, provided there is a proviso. First, what will be the purposes of these of these. Now, if the law giving you the blanket immunity from criminal liability, now you cannot use it in every circumstances. Under section 89, there are five principles mentioned under which it will be, four principles mentioned under which it will be able for the purpose of. First one is that these exceptions shall not be shall not extend to the intentional causing of death or attempting to causing of death. Okay. If such act in such a scenario it has been proved that it is intentionally, it is coming under the framework of intentionally causing death or attempting to cause death, this section will not be of any help. Now, secondly, that this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death for any purpose other than the preventing of death or grievous hurt or the curing of any grievous disease or infirmity. Okay. Now, the causing of death is permissible only when it is for the purpose of saving life. Okay, you can jeopardize a person's life only for the purpose of saving that person's life. Otherwise, you cannot. Thirdly, this exception shall not extend to the voluntary causing of grievous hurt or the attempting to cause grievous hurt unless it be for the purpose of preventing death or grievous hurt or the curing of any grievous disease or infirmity. So, first one is intentional causing death. This section will not be of any help. That is section 89. Okay. Now, second one is exception will not be available where it is anything which the person doing it knows likely to cause death. Third is anything which the person knows to likely to cause grievous hurt. Okay, extended to the voluntary causing of grievous hurt or attempting to cause grievous hurt unless it be for the purpose of preventing death or grievous hurt. And fourthly, this exception shall not extend to the abatement of any offense, for the committing of which offense it would not have extended. Simple. If for the committing of that offense this section is not extended, then abatement of that offense, in case of abatement of such an offense, this section will not be of any help. Now illustration, come to illustration. A in good faith for his child's benefit without his child's consent has his child cut for the stone by a surgeon, knowing it to be likely that the operation will cause the child's death, but not intending to cause the child's death. A is within the exception in as much as his object was the cure of the child. Okay. So the purpose or object of A is to what? The cure of the child. Again read it. A in good faith for his child's benefit without his child's consent has his child cut for the stone by the surgeon. That is a surgery for the purpose of erecting the stones. Okay, knowing it to be likely that the operation will cause the child's death. A knows that this operation is so risky and life threatening for the conditions of his child that it may cause to the death of the child, but not intending to cause the child's death. But the A or the doctor both do not have any intention to cause the death of the child. A is within the exception as much as his object was to cure the child. Okay. Now, coming to section 90, consent known to be given under fear or misconception. So, if the consent is given under fear or misconception, you cannot treat it as a consent, okay? Because a consent is only a consent to avail the help of general exception. It must be a free consent. Okay, so a consent is not such a consent, that means not a free consent as it intended by any section of this code. Every section wherever the consent word has been used, it is used in the sense of free consent. Okay, so a consent is not such a consent as it intended by any section of this code if the consent is given by a person under fear of injury or under a misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception. Okay, so in such a case, the person who is charged with the crime cannot take the plea or defense that the victim had consented to the act. Cannot take the defense if the consent was obtained or given under fear or misconception. Okay. Now, consent of insane person. The consent is given by a person who from unsound his consent or consent of a child, unless the contrary appears from the context. If the consent is given by a person who is under 12 years, a free consent. Okay. Now, coming to 91, exclusion of facts which are offenses independently of harm caused. Now, the exception in section 87, 88 and 89. What are the provisions? Let just look back at those provisions. What are they? 87 deals with act done with intended, act not intended and not known to be likely to cause dangerous hurt done by consent. 88 says act not intended to cause death done by consent in good faith for person's benefit. And 89 says act done in good faith for the benefit of a child or innocent person by or by consent of guardian. Okay, now these are the provisions which have been dealt or been dealt with under section 91. It says exclusion of acts which are offenses independently of harm caused. So the exception of section 87, 88 and 89 do not extend to acts which are offenses independently of any harm caused or harm which they may cause or be intended to cause or be known to be likely to cause to the person given the consent or on whose behalf the consent is given. Okay, now illustration. A, causing miscarriage. Okay, causing miscarriage unless caused in good faith for the purpose of saving the life of the mother or woman is an offense. Causing miscarriage is an offense except in good faith for the purpose of saving the life of the mother is an offense independently of any harm which it may cause or be intended to cause to the woman. Therefore, it is not an offense by reason of such harm, and the consent of the woman or of her guardian to the causing of such miscarriage does not justify the act, because the the abortion, operation of abortion is a penal offense under the Indian law. So, in such a case, he may be absolved from the liability of causing the operation because that purpose was not to save the person on whom the operation has been done, but it is for the purpose of what? It is for the purpose of causing the miscarriage, which is an offense under the Indian law. Okay. Now 92, act done in good faith for the benefit of a person with consent. Okay. Nothing is an offense by reason of any harm which it may cause to a person for whose benefit it is done in good faith, even without that person's consent. If the circumstances are such that it is impossible for the person to signify consent, or if that person is incapable of giving consent and has no guardian or other person in lawful charge of him from whom it is possible to obtain consent in the time for the thing to be done with benefit. Okay, so first of all, the conditions are nothing is an offense by reason of any harm which it may cause to a person for whose benefit it is done in good faith, even without that person's consent. See, 92 says even without that person's consent. If the circumstances are such that it is impossible for the person to signify the consent, or that if that person is incapable of giving, that person may be senseless, or the circumstances are such immediate operation is necessary, and waiting for the consent of that person to coming to his senses, or anyone on his behalf giving the consent is equals to the waiting for his death. In such a case, without that person's consent, if the circumstances are such that it is impossible for that person to signify consent, or if that person is incapable of giving consent and has no guardian or other person in lawful charge of him whom it is impossible to obtain consent in time. Remember that within time it is impossible to obtain that consent for the thing to be done with him with the benefit. Now, provided, first of all, this exception shall not extend to the intentional causing of death or attempting to cause death. Secondly, this exception shall not extend to the doing of anything which the person doing it knowing or knows to be likely to cause death for any purpose. Death, causing death, likely to cause death, in such cases also permissible, but where for any purpose other than preventing the death or derivation. Just I have said to you that you can jeopardize a person's life only for the purpose of saving that person's life. Okay, death or grievous hurt, or the curing of any grievous disease or infirmity. And thirdly, this exception shall not extend to the voluntary causing of hurt or to the attempting to cause hurt, okay, for any purpose other than preventing death or hurt. And fourthly, this exception shall not extend to the abatement of any offense, the committing of which offense is it would not extend. Okay. Now illustrations. This section have some illustrations. Now illustration A says Z throws from his horse and Z is thrown from his horse and is insensible. A surgeon finds that Z requires to be trepanned. A, not intending Z's death but in good faith for Z's benefit, performs the trepan before Z recovers his power of judging for himself. A has committed no offense. Now Z, illustration B, Z is carried off by a tiger. A fires at the tiger knowing it to be likely that the shot may kill Z but not intending to kill Z, and in good faith intending Z's benefit or for the purpose of saving Z's life. A's ball gives Z a mortal wound. Though A's bullet gives Z a mortal wound instead of the tiger, A has committed no offense. A surgeon sees a child suffer an accident which is likely to prove fatal unless an operation be immediately performed. There is no time to apply to the child's guardian. A performs the operation in spite of the entreaties of the child, intending in good faith. The child A has committed no offense. And D, A is in a house which is on fire with Z, a child. People below hold out a blanket. People below, okay, I'm sorry. People below hold out a blanket. A drops the child from the housetop, knowing it to be likely that the fall may kill the child, but not intending to kill the child, and intending in good faith the child's benefit. So, A throws the child from the housetop for what purpose? Drops the child from the housetop for what purpose? For the purpose of saving the life of the child. Okay. Here, even if the child is killed by the fall, A has committed no offense. An explanation, merely pecuniary benefit is not benefit within the meaning of section 88, 89 and 92. We have just read that merely pecuniary benefit is not a benefit within the meaning of these sections. Okay. So for this session, it is 76 to 92 we have covered. Now in our next video, we will commence from section 93. Okay.